Okay, so welcome to topic 3, week 2 of estate and tax planning. Now that we're past the financial market stuff, we get to get onto the fun stuff. So today we're going to be talking about succession and intestacy. Focusing, as you'll see when we look a bit of an outline, more on sort of the wills stuff. And then in the second session on Thursday, we will be looking at the rest of estate administration and some stuff on enduring powers of attorney. The nature of these topics is that as we get into them, they do kind of weave backwards and forwards with each other. So you'll see as we go along, part of, succession law relates to property. So next week's topic on what is and is not property is relevant. You also might be leaving stuff to trust, so that's relevant. You may be leaving behind a de facto partner or spouse, and so relationship property is also very relevant. So they all link together, which does, sometimes leave the issue of where do you start? We have to start somewhere. So we're going to start with some really basic stuff, but don't be afraid to ask questions, even if you think that they might be coming up in other topics. I will do my best to answer them as we go. However, I might also say we're going to get to that later on. Or I might alternatively say that's very complicated and answer your question via a stream message. Okay. So what we're going to cover today is a little bit about assignment 1, and for the most part, just figure out if you've got any questions and try to clarify things as best I can. And then we're going to look essentially at what do we mean by succession law, and as I like to do, giving you a bit of a mental map by suggesting 3 key influencing factors as to how estate administration is run. And then introductions to wills, the formalities of wills, including testamentary capacity, and how do you validate a will. So what happens if you have an informal will, for example, things like suicide notes, when can they be wills, and the concept of revoking and changing wills. Next session, we'll look a bit about the estate administration process and an overview of enduring powers of attorney. This, like all of the topics, these are big topics. We're not necessarily going to be able to cover everything, and the assumption is that you'll use these sort of PowerPoints, this discussion, along with the notes that you have been provided. Just as a bit of background as to where I'm coming from. So before joining Massey, I spent a few years in private practice in what we would call a small sort of general practice firm. And a lot of my job, not all of my job, but a lot of my job related to estate administration. So drafting wills for people, applying for probate, managing the estate administration, applying for letters of administration, and sometimes providing legal opinions for the partners when particularly tricky cases came up, and also acting, including sort of drafting High Court documents for challenges under the Family Protection Act, which we then resolved by what was called a deed of family arrangement. So my experience in this is largely practical. So I'm hoping to bring a little bit in of that, but the danger when you have this practical knowledge is I could make assumptions about some underlying things that you may or may not know. So please pull me up on that. So if you're like, I don't get it, please ask. Okay, so just the outcomes there. So just out at the end of this, hopefully you'll be able to outline general principles relating to wills, such as nature and purpose, and what are the prerequisites to a valid will. Be able to explain to other people and for yourself the importance of drawing up a will and other documents to protect an estate. Identify various gifts under a will. Explain the treatment of prior advances to beneficiaries and hodgepodge. not as significant for me as it was for the previous lecturer in this course, but it is significant if, for example, you've got parents who give 50,000 to one child before they die, maybe as a deposit for a house. And how does that all, balance out fairly in the end when the parents die, if the other children do not get the same sort of recognition? And looking at the effects of those various pieces of legislation, and then explaining the meanings of enduring powers of attorney and their relevance to the issues of testacy and intestacy. But first, assignment 1. Now, before I go through these points, I'm assuming you've read at least once the instructions. Are there any initial questions? Just waiting to see if anyone puts anything in the chat. Just as a note, so this is the first time we've done this, for better or for worse, depending on how you might see things. This is an alternative to getting you to write opinions on whether or not you think in a fictional fact situation someone's will is valid. My sort of view is that we're not trying to turn you into lawyers. What we're trying to do is help you to become the best possible sort of financial planners, or just, professionals advising clients that you can. And when you're doing so, particularly as you move up the food chain, you'll be doing it in a team of professionals of various sort of specialities, including accountants and tax planners and lawyers, etc. And a lot of the issue with that is making sure that you speak to some degree the same language, and that you understand and can identify when there are issues that the other professionals need to raise. And you would expect that those professionals would then raise, their own questions relating to your expertise with you. So you're working as a team. And so the purpose of the assignment is first point is to test your ability to understand, that role differentiation, and be able to understand legal issue, what the legal issues are, so that, for example, you could identify and tell a client you need to go see a lawyer, or you could see where some red flags might come up and you need to, for example, maybe even get your own advice about whether or not you should proceed in light of your own professional rules of conduct, etc. So linking to that, so you were just asking you to identify legal issues and questions. You don't need to write a legal opinion, so you don't need to, for example, say this is definitely the case or not. And start with the obvious. So this is not a test for you to come up with the most, contentious or controversial or obscure issue that maybe someone else wouldn't pick up. Start with the obvious and get that down on paper, because, in a business environment, you'd be expected to put the obvious down. And then depending upon, your word count or space, then you might want to refer to some other issues that you think you have been particularly clever at identifying. The main information you require should be in your materials, but further research is a good thing. Remember to choose sources with care. One of the librarians once referred me to, this acronym of CRAP, which is currency, relevance, authority, accuracy, and purpose. So please do not cite Wikipedia. Please do not quote lawyers' blogs. Some of them are very good, but for these purposes, you should be sticking to recognised legal commentaries, articles, cases, statutes, etc. And just as a note, professional presentation does not require fancy formatting. So while there are marks for professional presentation, I know all too well the stress and frustration that, particularly if you're using Word, you can experience when all your bullet points do not align. If one bullet point is not aligning and you're going to cry, just submit. Don't worry about that one, bullet points not aligning, etc. Just focus on making the structure and contents clear. And there is no set format, but a briefing paper should be concise and informative. Any questions or comments arising from this?
Just in this instance, are you expecting that because of the nature of this topic that we're going to be most reliant on acts and the law as opposed to cases and people's?
Probably, yeah. But for example, if for example you want to show that you have done a lot of background research, there's nothing wrong with putting on a bibliography. And I won't count it towards your word count if you just want to say, look, I read a lot in the background, but don't try and put it all in. Focusing on, just choosing your authorities well is important. But again, the point, hopefully, particularly those who have studied a law course before will know you don't get points again for the most obscure piece of law that you can find. And particularly if you think about, the purpose of this briefing paper, it's so that your supervising partner can refer to a case to a lawyer, and that lawyer will go, oh, I know exactly what case and what principle you're talking about, or I know exactly what statute you're talking about. So being obscure isn't going to win you any prizes. So we just know that, for example, not in this course, but in other courses, sometimes I've had references to Dutch civil code, Nigerian law, all kinds of things from some very interesting research that people have undertaken, thinking that they need to go well beyond the materials to impress people. Okay, so just as a starting point, it's easy to make this assumption, but we'll just start with providing a definition of what succession law is. And it's essentially the body of rules that governs how a person's property is distributed when they die. And so in New Zealand, our succession law follows logically from the law that recognises property rights. That's what we're going to look at, property in the next topic, during a person's lifetime, such as rights, ownership and use and exclusion of others. So again, that very wide definition of succession. What's worth noting is that what we consider inevitable or, really straightforward rules of succession, and particularly issues relating to testamentary freedom balanced against the obligations to provide for, children and other dependents, is that in some jurisdictions, they will have, often with civil codes, where the entire law is set down in one sort of set of legal rules. There is something called forced heirship, and essentially it will set down very prescriptively who gets what. And it can be quite difficult to depart from that. Versus in New Zealand, where we've got a hodgepodge of different laws that kind of all sort of work together and provided, but have also a degree of uncertainty. And that is why in the chat, and I will also link to it in the recordings, I have just in case you're interested, included a survey that was undertaken by the University of Otago about New Zealanders' attitudes to succession, because particularly when we've got a very changing society, so our rules of succession were predicated on a very white English model, where people had one marriage and they were married their entire lives, where Often it was the man who was working, you've got the children, those concepts of primogeniture, like going down to the eldest son, which still exists to some extent, for example, in farming families. All of that is changed now that we've got different cultural sort of groups, for example, Pacifica and Asian cultural groups may have different ideas of what should happen, and also increased recognition of Māori tikanga, and also just general sort of more fluid blended families. So just as we're going through that, have a sort of think about whether or not you think the current law is fit for purpose, and whether or not that is, you know, what your role would be possibly as an advisor in trying to sort of explain to people why these wills are important and how they might be able to tailor wills to their own cultural needs, etc. So as noted, the foundations of our succession law come from English common law and statute, as well as I said, social and economic conceptions of property ownership and family obligation. So just as notes, for example, under the law of coverture, until the 1880s, women in England and then following through to New Zealand married women weren't able to own property. So as soon as you got married, all your property sort of was the possession of your husband, which is why often rich families created trusts for those wives. So you've got all of these kinds of conceptions going on which feed in to our current sort of rules relating to inheritance, etc. So we've got a lot of case law, but for the most part, we're looking at statute law here. So we're looking at the Wills Act, and we'll look quite a bit of that today. Looking at the Administration Act of 1969, the High Court rules, which are a bit of a complex beast. I just included those, you're not expected to know them, because they govern how you will apply for probate and letters of administration, which we'll talk about in a few seconds. Property Relationships Act, so as you know, that's how property is to be divided during separation and death between married and de facto and civil union couples. The Family Protection Act, which sets out what can happen when, you know, a testator or will maker has failed to meet what might be considered their moral duty to provide for a spouse, children, or even in some circumstances, grandchildren. Law Reform Testamentary Promises Act, which is very limited in application, but when you say in exchange for you doing this for me, like caring for me on my deathbed, I will leave you my house, that can be considered a binding promise. The Succession Homicide Act essentially puts into law something that, you know, morally we would consider sort of repugnant, which, you know, or actually make sure something that we would consider morally repugnant doesn't happen, which is that if you kill your father and your father does not leave a will, or if your father leaves a will naming you as the sole beneficiary, you should not be able to benefit from that. Just as a quick note, because we don't cover it in this course, but it is quite important just to note that it is there. The Tūteri Whenua Māori Act covers things like Māori land and the succession to Māori land, and that the Māori land courts look after that. So there's a separate process that you do need to go through if someone leaves Māori land, because it can only be succeeded to by sort of blood relations in certain circumstances, and you need to go through a particular process for that. So we're not covering that, but just note that there are these carve-outs. Any questions or comments so far? Great. Okay, so I realized this is tiny writing. I got a little excitable when I was writing this out. So From my perspective, and again, you might see different comments from different people, but I thought this might be a helpful way of you understanding the sort of different factors that go into how an estate will be administered. So whenever someone dies, they will usually leave an estate, and that could be a solvent or an insolvent estate, and we won't be touching on that, but just note that there are provisions in the law, including in the Insolvency Act and the High Court rules, that deal with what happens if someone leaves behind more debts than assets. But the factors are whether, if you're taking into consideration how is this estate going to be administered, what does this estate look like, who's getting what. The first part is ascertaining, what is the property and what property that the deceased had an interest in, which is going to fall into the estate, because that's not all of the property. So as we'll look at, joint property passes by survivorship, and that includes joint bank accounts as well as jointly owned real estate, and trust property, which they may have an interest in, which we'll look at later, does not fall into the estate. Also, if by virtue of the fact that, for example, the house passes by survivorship, the bank account passes by survivorship, and all this person has is $11,000 in KiwiSaver, then you don't need to apply to the High Court to administer the estate. And there is a process of statutory declarations, etc., that you can use to administer the estate. And so one actual option for estate planning is to actually make the estate itself as small as possible prior to death, so that it doesn't need to go through probate or letters of administration, and that's entirely valid. Just as a note, though, that could be challenged by others who try to claw back assets into the estate, often, for example, children who are unhappy that a spouse gets everything. So that's the property. Also, does the existing property match what's in the will? So if you say that I leave my house at 123 Burns Ave to Sally, that relies upon the fact that you still have a house at 123 Burns Ave. If you don't, then that gift is going to fail. Any lawyer who allows that kind of specificity in a will is usually going to get in trouble unless the client has made very clear that that's the instructions. The next question is there a will? If there is a valid will, and we'll talk about validity in a few seconds, then the distribution of the will is in accordance with that terms. If there's no valid will, then distribution in accordance with intestacy, and we're going to look at that in the next session. If you've got a will, you apply for what's called a grant of probate. If you don't have any will, then you apply for letters of administration. What's noteworthy there is, just from a practical point of view, probate is much easier to apply for than letters of administration. Letters of administration is essentially more paperwork. And you also have to nominate the size of the estate. So this isn't covered anywhere, I think, in the notes, but what's interesting about, for example, New Zealand probate versus what you might have seen overseas is once a will is probated, it does become a matter of the public record. So you can actually apply to the High Court for a copy of that probate, and also, for example, a copy of that letters of administration, and that's anyone. And after a certain amount of time, all probated wills go into the archives. So if you, for example, wanted to find the probate of a will of your great-grandmother and she died in New Zealand, you possibly can find that. But you don't have to list what the assets in the estate are, which is quite different. For example, I can recall when they talked about the death of Prince, the singer, and they talked about, these are the things that he left in his estate, and we found this out from court documents. You wouldn't be able to find that out in New Zealand unless the will was challenged. And then you'd have to apply for access to those documents. And then the next thing is when you're looking at validity of the will, you're looking at the form, the capacity of the will maker, and was it made with their free intentions. So by that, I mean, was there any undue influence or duress imposed upon the will maker? And I think that's covered in the notes, although it's not covered in the slides. And then people, did this person leave behind a spouse or de facto partner? And in addition to that, were they separated? There's some quite interesting complexities that come up from if they are separated, particularly if it's a spouse and there's no separation order in place. Are there children? For example, and adult children, just younger children, dependent. For example, would they have disabilities? Are there children from prior relationships on either side? So, for example, if you have Sally and Tom, and Sally has 2 children from a previous relationship, and Tom promises to provide for those children under his will. So everything first goes from Sally to Tom by survivorship, and then Tom says he's going to provide for those children. How can you enforce that? And are there other interested parties like relatives and carers? And it also links to any family trust. So as you can see, each of those different factors, and there are multiple sort of variations of those, will give each estate a slightly different look. And some estates are really, really simple, and actually the majority of them are, particularly if the beneficiaries are all kind of chill. But some estates can be quite complex, either by nature of the property and the way that the will is framed, or just because the people are difficult, or there's some kind of tension between certain family members or not. Any questions or comments?
Just out of your experience, would you say that it's common for there to be issues or not? Like, because I feel like it would come up reasonably often, that even if they're only small.
It comes up reasonably often, but less often than you think. Sometimes I once got caught up on like a 40-minute phone call from someone who said they wanted to challenge the will. So I shouldn't get onto these war stories, but essentially she was really upset with her mother because all the children got 1/3 of the residue of the estate, which we'll talk about. But the mother also made specific gifts of different property, and some of the other children got like really fancy things, and she got a crock pot. And she saw that as like this really terrible thing, that her mother was essentially dissing her in the afterlife, and that needed to be challenged, despite the fact that she was going to get, exactly the same amount of the entire, main part of the estate. So sometimes it can be quite petty. And other times you have like a $10 million estate and everyone's quite chill and doesn't really ask you when the money's coming.
Yeah, right. Thank you.
It's hard to know.
Do they? Oh, sorry.
It's all good.
The other side. I just had a quick question about the beneficiaries of a will.
Yep.
Are they liable for the debts of an insolvent estate?
No. However,
Okay.
for example, and depending on how a will is framed, you may, for example, have the situation where for example, if you're leaving a property with a mortgage on it, that mortgage might either have to be discharged using proceeds of the estate before anything can happen, or you might, have to take depending on how the will gift is framed, the mortgage might have to transfer through, and that again has the issue of the permission of the bank. But sometimes what will happen is that the will maker will be more generous in their will than they can actually afford in reality in terms of their property. And so there's various sort of mechanisms in law for gifts, for example, to redeem. Gifts can fail, which means they don't happen, but also gifts can be reduced to equalize across the estate. It gets quite complicated to deal with that. But that's partly why you want an updated will. so that your existing will matches the kind of property that you do own and is fit for purpose.
Oh, thank you.
Michelle, one question.
Yeah.
If you go back to the other slide, the property, you mentioned about small estates under 15,000. Is that a threshold?
Yeah, so under the Administration Act, and I think it's section, and then so there's a provision under this Administration Act which allows that if you've got a small estate of under $15,000 in banks, etc., and even KiwiSaver funds can release the things. It's actually called the prescribed amount, and then the prescribed amount is set by regulation. And there's some arguments that that should be pumped up because it's been sitting at 15K for a while.
Yeah, let's talk about that. It's quite a small amount.
It is quite small, and it's not unknown, for example, for someone to come through and someone's died and all they've left is a KiwiSaver or one bank account, and you've got your fingers crossed that it's under 15K. Because probate, so it's $200 to apply for just filing in the High Court, and then you're probably, if even a nice lawyer is probably going to be charging you about $1,000 to get probate, and it heads upwards from there. It's hard, and don't ask me about general estate administration costs. It's everyone has very different ways of calculating it, but you've got to apply for that. But technically, it's also $15,000 in each institution. So technically speaking, if you leave $8,000 in ANZ and then you've got a BNZ KiwiSaver with 12,000 and all that kind of thing, each one of those is a small estate, and you don't need probate. But you still need to be the personal representative to fill in all the forms, etc. But yeah. It's a good thing about estate planning. Sometimes the best thing you can do is empty out what is actually going to be the estate. And sometimes people can just make gifts before they die. For example, people on cancer wards might be just starting to, have their capacity checked, make sure everything's good, and then just, get it all out. So we've sort of touched on this, but this is just a link to keywords. So we've got testate, so that's when there's wills, and intestate, when there's no will. The old school terminology for what is now called a will maker is testated or testatrix. And grants of administration. So the grants of administration is essentially the High Court saying, yes, this is a valid will, or we agree that this person should be the personal representative who's going to administer this estate when it's intestacy, or when there's a valid will but no executor available, etc., then it's something called letters of administration with will annexed. What's worth of noting is the High Court takes pedanticness to an extreme, and that's one of the reasons you want to get a professional in to draft those applications. Usually I would, if you can do something without a lawyer, I'm happy to sort of suggest you do so. But just the amount of headaches it would cause trying to just make sure that everything is perfect, I would say pay a lawyer. Or an trustee company to also do it. Executor, executrix. Most used to use the executrix for the female. Most now is just completely neutral, executor. And I actually haven't really seen in my practical sort of experience any reference to administrix. Just as a quick note, people should always name or make sure that there's an alternative person who can act as the executor. Otherwise, if your executor dies or lacks capacity and that's the only executor you have, then you've got letters of administration well annexed, which is like even more complicated than letters of administration. It's a headache. Trustee isn't just a trustee from a formal trust, and we'll look at that, or trust as you might see, but can also arise when executors continue to hold property in trust for beneficiaries for a particular purpose. And might be because of an age, or there might be something like a life interest, etc., that is being held. So essentially, you start with what is a will? And a lot of people are like, I know exactly what a will is. But there's, what people's common sort of conceptions of a will is, and what the law considers a will. And there's a lot of sort of case law that's developed, an Older Wills Act, which had all very old school language. And then we've got the Wills Act 2007. So will means a document. What's noteworthy is that document has quite a wide meaning in the law and the Act. And so technically speaking, while there hasn't been any, to my knowledge, any case law on this, things like those video wills or sort of online sort of other recordings, etc., could become or be seen as a document. Usually, however, when you're looking at documents, it's more traditional, it's more sort of notes, etc., but also emails going between parties, electronic documents that haven't been printed out. Those can also be considered to be potential wills, although the difficulty comes when we look at those formalities further on about signing and witnessing. So it's made by a natural person. So remember, a person in law can also be a company. So this is saying a will cannot be made by a company or corporation. And it does any or all of the following things. Disposes of property to which that person is entitled when he or she dies. Disposes of property to which the person's personal representative becomes entitled as personal representative after the person's death. So for example, if I said in a very simple will, I give everything to my sister to distribute as she sees fit because I trust her, if it meets the rest of the formalities, it doesn't actually need to say what I want to happen to my property. And one of the famous examples of a will that has been validated was just a guy who scrawled on a piece of paper, all to mother. So they can be quite basic, and appoints a testamentary guardian. Testamentary guardians, as you may guess, a type of guardian that's also recognised under the Care of Children Act. And guardianship doesn't mean care of the child, it just means a say in the care of the child. So for example, if you've got separated parents and one parent dies and names X as a testamentary guardian, that doesn't necessarily mean X has a right straight away to have that child in their care, but they do have a right to have say in important decisions about the child's life and may be able to apply to the court for care of the child.
Sorry, just a question.
Yes.
So for the testamentary guardian, so does it act something like the power of attorney? Is it something similar to that?
It's more like just a straight guardian, because it's a child under the age of 18. So guardianship ends at 18.
Okay.
Yeah. So I should have made that clear. Guardianship ends at 18, which is relevant to a point I'm going to make capacity a little later. And I look at the time, so I'm going to have to go through this because I've been talking too much. So wills, persons over 18, or if you're under 18, you're married in a de facto relationship, or you have obtained the approval of the family court, or you're a military or seagoing person. And there's actually special rules relating to the validity of military seagoing persons, because they know it's, often when you're facing death, you can't get witnesses, and you just scroll what you want to happen on pieces of paper. And so the law is quite sort of flexible with that. And this is the key point. So you'll hear a lot and you'll read a lot about testamentary capacity. But basically that is, does this person have the capacity to make a will? And the starting point that there is a presumption of capacity and that there is testamentary freedom. This is relevant as well for enduring powers of attorney, which we're going to get to, but capacity is a fluid concept influenced by the type of decision, time of day, alertness and mood, etc. And none of us have perfect capacity to make all legal decisions. So I would challenge you to say that you fully understood the terms of the last contract you entered, like credit contracts in particular, mortgages. If you understand the terms of your mortgage, then good on you, you're a rare person in terms of the detail. You can generally understand, you know, in exchange for the bank giving me money, I must pay the bank back, and if I don't, there are going to be repercussions. But if you don't, you don't need to understand it line by line. And just as a note, will makers do not need to make wise decisions regarding the disposition of their property. They just have to have sufficient understanding. So if the will maker has capacity and is just an cantankerous old man who's decided that he hates all his children because they keep telling him he needs to go into a home that's going to care for him, and he cuts them all out of his will, then he's likely to have capacity. That will is still likely to be valid, but it could be challenged under other grounds, including that Family Protection Act. Yeah, so if there's evidence, so essentially there's a presumption of capacity, but if there is evidence which raises doubt about the mental capacity of the will maker at the time, then the party seeking probate is required to satisfy the court that the will maker had the requisite mental capacity. So essentially you're not supposed to submit a will when you know that the mental capacity issue is a bit dodgy. What could also happen is parties may, like if you consider that your mum made a will that wasn't valid and you're not named as the executor, you can actually lodge essentially what's a caveat with the High Court. So the High Court will look at things in more detail. And the standard of proof on the issue of testamentary capacity is the balance of probabilities. And it's made at the time the will was made. So you can't say, you know, I saw them a month later and their behavior a month later is not necessarily going to be determinative. And again, also because, for example, with things like dementia, people can have capacity at one time of day and not others. It's not always a nice, straightforward decision. Also, challenges on testamentary capacity because families are messy will often also argue things like undue influence, like one family member was placing a lot of influence, just maybe a bit of few guilt trips, etc., on a family member. So they still kind of knew what they wanted to do, but were reluctantly signing that will, or sort of were using duress and kinds of threats, sometimes even economic threats. You can't stay with us, or you can't see the children, the grandchildren, if you don't recognize me, X and Y. So those might also come in. So a challenge to testamentary capacity is also often going to be a challenge to some of those other things. So the questions are, did the will maker have a sufficient understanding of the fact that they were making a will and the effect of doing so, the extent of the property being disposed, and the moral claims to which they ought to give effect when making testamentary dispositions? The simpler the will, and if the more less capacity you need, really. If you're just leaving behind a few bank accounts to your 2 kids who you're also naming as the executors, that does not require as much capacity as if you were leaving behind an entire media empire or whatever. So like in the TV show Succession, you would need significantly more capacity to be able to make those more complex decisions. So again, not nice sort of simple case of yes they do, no they don't. And so just as a note, and this can also be helpful for you and your own role, need for good record keeping and file notes. And also sometimes you write contact clients, confirming your advice, and the role of seeking medical advice, which needs to be distinguished from just what is your diagnosis, because someone who can have a diagnosis of early stage dementia can still potentially have testamentary capacity, and as we'll discuss, can still have capacity to create an enduring power of attorney. The question is that the neuropsychologist or the elder physician needs to, or geriatrician, needs to have the test and apply that test in relation to the specific cases. And sometimes that will also mean you provide a list to the geriatrician of the kinds of property that this person has and what their instructions are, and get them to confirm that. So, who has seen a valid will? I'm hoping you guys have made one. The main reason, even if you think, oh, I've got a small estate, I'm happy with where things are going under the rules of intestacy, is if you care about your family members, the rules of intestacy and just getting less of administration is a bit more stressful for them. So probate just makes things a bit clearer. But essentially a will needs to be in writing. It needs to be, but that's quite wide. Again, document, writing, these are quite widely defined terms. It needs to be signed and it witnessed by both or present. So there must be two witnesses who must both be present when the will maker signed or acknowledge the signature as their own. So the will maker could sign it beforehand, but then needs to take it and say, this is my signature, witness it. There are provisions in the will and in terms of how it's wording for things like blind people, that you have to read the will entirely to them, but you can get in trouble for not having the attestation clauses properly sorted out, and it's got to be, you know, the name, the occupation of the person, and just generally the city that they live in. So you need to be able to identify those witnesses so that if there are questions about the validity or capacity, that those can be brought up. There were some special sort of workaround rules that were introduced over COVID, but lockdown, but those have been removed, and they've also made things very messy. Just as a general example, in case people haven't never seen a will before, and I'm just keeping to look at the time, that this is what a very simple will would look like. If you're just leaving everything to your husband and wife, and you make them your executor and trustee, they pay all the debts, funeral and administration expenses, and you'll see, and any duties payable on my death. Note, New Zealand does not have estate duties or inheritance taxes, which is quite an important point, but I'm not a tax expert, so I'm staying out of that. And then you'll see signed by that person and attested by us in his or her presence. And that wording is actually quite important, and as is where the signatures are, etc. But this is just an example graphs from a precedent. You won't be able to read all the writing, but this is what a longer will may also be have, and you'll see that it has more detail. For example, if you read it, there's testamentary guardians there, there's what's happened to the body. We don't go into it a lot, but technically speaking, under law, there is no property in the body. So the appointment as the executive gives the executor the power to make decisions about what happens to, you know, funerals, burial arrangements, etc. But what's in the will in that case isn't necessarily binding. And there's a very famous case called Takamori and Clark, where the Supreme Court considered, you know, possession of the body where it should be buried, particularly balancing it out with Maori tikanga. So just as a note, that's more of a statement of wishes rather than binding, unlike the rest of the content of the will. You're not expected to read that in detail, but I can sort of steer you towards some precedents if you want to have a look at them, but I'm not encouraging you to write your own complex will. However, if your will just looks like that, go ahead, make it. You can even use some of those online will makers. The most important thing is having it in a safe place where everyone knows where it is. So I'm just looking at the time, so we might need to go through this a little bit fast because we have quite a bit to cover in the next session. Informal wills. So if a will isn't necessarily sort of meeting all the requirements or looks, then it's going to be, you could potentially apply for it to be validated under section 14, and we're going to look at that. And the questions are going to be like, had the material been created by the will maker? Wasn't intended to be a will? Did it express testamentary intentions? And that can be quite difficult at some times to sort of figure that out, particularly for things like suicide notes, or and sometimes there's been some really sad cases of people sending text messages before they die to people about what they want to happen to their estate, and is this a will or not? But again, it's those questions that the court is going to turn their mind to. But the best thing is, if you're a financial advisor and a client said, we found this in Dad's drawer, you'd be sending it to a lawyer. You wouldn't be making your own decision about whether or not that's a valid will or not. Hopefully not, anyway. So essentially, it used to be the case that the Wills Act 1837, which was a UK piece of legislation which came into New Zealand, brought into New Zealand law, essentially said you need to meet these formal requirements, or it's not going to be a will. It's a case of intestacy. Now the case is that the High Court will do its best to see if there are grounds to make something a will. They still need to be satisfied that, as we looked at before, it expresses the intentions of the deceased person, or their testamentary intentions. And by saying it's easier doesn't mean that it is easy. As I have referred to earlier, when it comes to validation of wills and just general probate, the High Court is very persnickety. Like, if you will need to explain, for example, in affidavit form, so that's a sworn statement, why there might be, a spelling mistake of someone's name, even if it's just, for example, the executor, etc., and if the executor has married since they were named as an executor, all of that kind of thing needs to be addressed. And that's just for a standard valid will. So make sure your wills are up to date. Again, further sort of repetition there. So they're looking at the document, evidence on the signing and witnessing of the document. So if it's been witnessed by someone, it's going to be given greater weight than if it hasn't. One thing I haven't referred to in the slides is if a beneficiary witnesses a will, then the gift that they receive, they will fail. So if you say everything, I leave my house to my daughter, and your daughter witnesses the will, then that gift will fail, and your daughter will not be able to get that house. However, if you just say, I name my daughter as executor, then the executor can witness the will under the Wills Act, which is actually a change from what it used to be under the old legislation. And I know this because we had a very, very well-established partner who had since retired but had been named as an executor, who was trying to get out of being an executor by arguing that he had signed the will. And I checked the law and he couldn't get out of it. And he had no other grounds to step back. You don't have to be the executor, but you might have to deal with the consequences of making things messy for other people by not being the executor. Again, and also evidence of statements, evidence of the deceased person's testamentary intentions, etc. So it's a bit of a repetition. And overall, it sort of must appear to be a will. So it doesn't matter necessarily where it was, and we'll talk a little bit about where property is and those concepts of movable and immovable property a bit next session. What's worth noting is the general rule is for movable property, New Zealand wills can potentially sort of cover that, but you may need probate in other jurisdictions. So for example, I had a deceased who invested quite a bit in the stock markets, and unfortunately he was very good at that, but he played the stock markets himself, and so he didn't have a agent or stockbroker, and so we actually had to apply for New Zealand probate to be resealed over in Australia, and we had an agent choose the best state of Australia, because each state has their own rules, in order to reseal that probate, and then the agent could then apply to sell those, to get the shares transferred through to the estate in New Zealand, and therefore could be sold. So you need to also take into consideration where the property is and what the nature of the property is. Although that doesn't link to validity, that's just another side question. So traditionally, you'll see something called a codicil. And a codicil would be a change to the will. Sometimes, for example, you know, each time you wanted to cut a particular grandchild out of the will, you'd make a new codicil. Or if you wanted to change the executors, you'd make a new codicil. Codicils, for the most part, come from a time when you didn't have ease of printing and word processing. So when each time a new will needed to be typewritten out and needed to be precisely correct with no errors, and considering all the formalities, it would make more sense to make a codicil. These days, considering all that's required is that the law firm pull up the most recent version of the will, make the required changes, and then get it signed. You would nearly always update the will entirely. Otherwise, for example, you know, a codicil could be made if a lawyer was attending on a client and the client said, oh, I wanted to cut X out of my will. The lawyer might be able to get an online version of the will. It might be scanned into their deed system, might be able to see what it is, but they might just make a short codicil there. But generally speaking, make a new will. Don't do codicils, because codicils also need to be, you know, put through the probate process, all the attachments, extra wording, extra problems. Revocation by the execution of a later will. So you'll see on those examples that I attached that the first thing it says is I revoke my earlier wills. They used to use all kinds of, you know, whereby, herefore, hereunto, etc., etc. I giveth and bequeath. But modern legal drafting would has got rid of those. It just says I revoke my earlier wills, and or you could write in another signed document. So if you're not with your lawyer at the time, and you could sign a new document with witnesses saying I revoke all my current will. If you marry, unless the will is in contemplation of marriage, then that will is going to be revoked. What that could mean is therefore that you creating a situation of intestacy, which may not be ideal for yourself or for your new spouse. And any other act which may satisfy the court, or this animus revocandi, which intention to revoke, which include clearly intentionally burning the will. So that's why that little picture of a fire is there. And that is the end, and it's 1:01. Any questions, any comments? We'll be looking at the estate administration process and some of those pieces of legislation that you can use to challenge it in the next session. Okay, so no additional questions. I will stop recording.